This Honorable Supreme Court of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court. Please be seated.
Good morning, everyone. Welcome to the September 22 Knoxville docket. Also, we want to welcome those who are watching us by live stream on our YouTube channel. We have two cases this morning. As you know, it's 30 minutes per side. If the appellant wishes to reserve time for rebuttal, please let us know that when you walk up and start your argument. In the last few days, we've lost two stalwarts of the Tennessee judiciary. Judge John Everett Williams, presiding judge of the Court of Criminal Appeals from Huntington, and Judge Phil Smith, presiding judge of the 20th Judicial District in Davidson County. Of course, he's from Nashville. And we're going to miss both of them very much. And I wanted to stop and observe a moment of silence in their memory and in their honors. Thank you all very much. Mr. Hibner, you may call the first case.
State of Tennessee versus Johnny Summers Cavin.
Good morning, Your Honors.
Good morning.
Good morning. Good morning, and may it please the court. My name is Mitch Raines. I am with the Appellate Division of the Public Defenders Conference, and I am here today on behalf of our client, Mr. Johnny Cavin. At this point, I'd like to reserve 10 minutes for rebuttal. Thank you. This case presents two issues for this court. The first is a jurisdictional claim, and then the second is a substantive review of the restitution order. In our original application, our Rule 11 to this court, we asked that the court only evaluate the jurisdictional claim, and in its response, the state asked that this court also substantively review the restitution order. So if this, we would ask first that this court, as to jurisdiction, finds that the amended judgment issued by the trial court did constitute a final judgment and therefore was ripe for appeal to the Court of Appeals. And should this court choose to evaluate the restitution order, we would ask that you find that that was improper.
Mr. Raines, was the issue of the Court of Criminal Appeals subject matter jurisdiction raised by either party in the Court of Criminal Appeals? In the briefing, I've reviewed the briefs. I don't see any reference to that.
No, Justice Lee. In the original appeal, Mr. Cavin raised there was a jurisdictional claim that the trial court didn't have jurisdiction to amend the original judgment because it had been 30 days since that had been filed. The Court of Criminal Appeals, and I think correctly noted that the guilty plea in this case, or as it relates to the theft of property, called for a restitution hearing. And since that hadn't taken place yet, the trial court did still have jurisdiction to amend the original judgment to include the restitution that was decided at a later date. But the Court of Criminal Appeals on its own decided that it didn't have jurisdiction and stated that it didn't because the trial court didn't state the restitution in terms of an installment plan. It was
Was the issue of jurisdiction brought up at oral argument? Were the parties given any opportunity to address it?
I was not the counsel at oral argument, but I do not believe so. I know that it wasn't in any of the written briefings, and I don't believe it was brought up at oral argument either.
It was assigned on brief, so from my reading of the CCA opinion, there was no oral argument. It was taken in on briefs.
Then,
do you think?
I will defer to Your Honor on that. I don't recall if there was oral argument or not.
So I guess the point is neither party had any input into the Court of Criminal Appeals decision regarding subject matter jurisdiction.
That's correct, Your Honor. Neither Mr. Cavin nor the state had any input or argument before the court on that issue. So
is there any daylight between your position and the state's position on the subject matter jurisdiction at this point?
We are in agreement as to jurisdiction. The only difference might be that an issue of terms, perhaps. I, in my brief, argue that if a trial court has broad discretion when setting a restitution order. It can dictate the terms of payment if it so chooses to as an installment plan. It can also set a shorter time frame than the length of the sentence. The statute, Tennessee Code annotated 4035-304C, which is the statute on point, says that the court may not establish a payment or performance schedule extending beyond the statutory maximum. So it doesn't prohibit a trial court from setting a shorter payment term. So in my brief, I argue that essentially if a trial court meets the bare minimum, which is it establishes the amount that is due and it sets the payment term as during the course of probation, as in this case, or as it relates to just the length of the sentence, then that creates essentially by default, and I use that just for clarity, and the state in its response did note in a footnote that there's no reason to coin that essentially as a default as long as the state, or as long as the trial court, sets a total amount due and a time period. We don't need to get into default or not, that kind of thing.
So here the judge said, the trial court said the defendant would pay the restitution during the period of supervision.
During the course of probation.
Okay, so would that be 2.5 years or over the 4-year period?
Because restitution was tied to the theft of property over $2,500, it would be tied to that 2.5-year probationary period.
Mr. Raines, we know that the trial court does not have to set periodic payment on restitution, but does it make any difference that, in my experience, if the defendant or probationer was not meeting the payment plan that was set out, $100 a month, whatever, I got many revocation warrants saying, he should have paid $1,800, but now he's only paid $1,400. Does that make any difference on our analysis here?
I don't think so, Your Honor, because ultimately that decision can happen if there's an installment plan or monthly payment terms that are directed by the court, then it can happen theoretically every month that they could be not in compliance and have to explain to the court why they're not making their restitution payments. In this case, when it's set during the course of probation, that means that he has until the end of the 2.5 years to pay the full $5,500. If he doesn't, then a violation warrant can still be issued at the end of probation. And at that point, the trial court still has a couple of options. It can order that the probationary period be extended to allow for more time to pay restitution. There's also a mechanism within 4035-304 that allows for that criminal restitution to be converted into a civil judgment. So that it's not dictated in terms of an installment plan doesn't remove that authority from the court or that ability to review the restitution. It could just happen. It's just not going to occur at a set rhythmic time.
Does the record indicate whether the probation officer for Mr. Cavin subsequently set a payment schedule?
I don't believe so, Your Honor.
Okay.
Mr. Raines, I want to go back to your discussion a few minutes ago about kind of a default time for payment.
Yes, Your Honor.
Do I take it that you would now kind of agree that to the extent there's any default rule, it would not be necessary to apply that here because there was actually a specification of the time for repayment? Or is it still your position that this case requires application of the default period being the period of supervision?
I think that ultimately my language is as it relates to default was just trying to just my own way of trying to clear the water, I guess, and provide that ultimately, as long as a trial court finds a restitution amount and then sets a time period, that's all that's required under the law.
So did the court do that here? Did it specify the time for repayment?
It did,
by
Your
saying
Honor.
that it was during the period of probation?
Yes, Your Honor.
Okay.
By saying that it was during the course of probation that
that satisfied that statutory requirement?
Yes, Your Honor. That would tie it to the 2.5 years. So our argument is that he had 2.5 years to pay $5,500.
One more question, and this goes to the record. Was there an amended judgment entered as to count 2? On my review of the technical record, there was an amended judgment as to count 1, which I believe was the burglary charge, but I did not see in the record an amended judgment as to count 2, and I was curious as to why.
I would have to. I don't want to tell you anything that I don't know, so I would have to check the record. But
Okay.
I believe that there was. I may be mistaken on that point, but I do believe that there was, because the best of my recollection, count 1 and count 2 were tied. The guilty plea was entered at the same time on both of those issues. But it's my position and my understanding that the restitution order is only related to the theft of property. It was statutorily required that the trial court at least evaluate restitution, whether it be due to that specific charge. And so that's why it would be tied to the theft of property charge.
Exactly what relief are you seeking from the court, and given the current posture of this case?
Your Honor, ultimately, Mr. Cavin is asking this court to find that there was a final appealable judgment that was entered by the trial court after it amended judgments finding the restitution amount. And we would go beyond that also, because the state raised it in their response, and ask that if this court review the restitution order, ultimately find that that restitution order did not sufficiently consider Mr. Cavin's ability to pay, and also that the state did not provide sufficient proof to its value of the wood that was taken. And so remand for either a new restitution hearing, or if the court finds that there's sufficient evidence within the record to make a determination, order that Mr. Cavin pay less than the $5,500. There was proof put on at the restitution hearing that Mr. Cavin valued the wood to be around $900, so we would ask for a figure closer to that.
Didn't your client plead guilty to theft of at least $2,500?
That's correct, Your
in
Honor.
value? Okay, I mean, doesn't that foreclose any argument that the restitution, I mean, setting aside ability to pay, but if we're just looking at the value, or that the loss, pecuniary loss to the victim, I mean, doesn't that guilty plea foreclose any argument that it's lower than $2,500?
Not necessarily, Your Honor. It's very common for criminal defendants to plead out of range, and that he pled to theft of a minimum of $2,500. I don't think sets a floor or a minimum threshold for restitution. The way that the statute is written, there's a lot of discretion on the part of the trial court, and at the time, though, they had to consider criminal defendants' ability to pay. That's changed since January of this year. But the mandate that you have to consider their ability to pay, I argue, also means that the restitution amount has to be related to that. The point of restitution is to not only punish someone, but also to try and make a victim perhaps not whole, but allow them to recoup at least some losses. But because we don't want to also essentially make a pauper out of our criminal defendants, there needs to be a lot of latitude as far as moving below any kind of minimum threshold or anything like that.
Mr. Raines, is there anything in the record that shows that this defendant pleaded out of range? Because trial courts are very careful to put all that on the record if they do that.
That's not specifically noted, Your Honor. During the proof by Ms. Jill Rich, she did testify that originally she claimed that there was $1,000 worth of property that had been taken, and then she later adjusted that to $10,000. So I'm not sure when that evaluation, other than at the restitution hearing, occurred.
But didn't,
A layperson under 701B can testify about the value of their personal property, can't they?
Yes, Your Honor, but they have to have a sufficient factual explanation, I guess is how I'll call it, as to be able to explain what their evaluation is. Here, Ms. Rich originally testified that she said that it was $1,000 in the initial report, and at the hearing she claimed that it was $10,000. She said that she went and spoke to like a wood merchant, someone who sells these kind of woods, but there's no testimony or no evidence in the record related to what kind of estimates she got from that person or what they told her about the value of her wood.
Was there a hearsay objection during that hearing?
No, Your Honor.
Okay.
But didn't Judge Goodwin go through a fairly detailed examination of the record in making the amount of restitution determination, and he basically concluded that neither party was very credible, but came to a decision based on his review of the record, his understanding, which was somewhere between what both parties were saying. Doesn't that sound a whole lot like exercise of discretion?
Well, Your Honor, in the record, the trial court did spend a good bit of time going over Ms. Rich's testimony, highlighting the inconsistencies in her testimony based on the monetary valuation that she gave, as well as the number of pieces of wood that were missing in the course of time, that kind of thing. And the trial court did also note that Mr. Cavin lacked credibility based on his prior criminal history. He had some thefts and burglaries in his past. But there wasn't an analysis as to Mr. Cavin's ability to pay. The trial court said that it considered Mr. Cavin's ability to pay, but there's no explanation as to what that means.
What in your view is required? I mean, I think you say in your brief that it has to be enough analysis to permit meaningful appellate review or something to that effect. I mean, what in your view is required? Do there need to be specific findings? Is it enough that there's something in the record showing that was a factor that the trial court considered?
I think that there are several different ways to get to a sufficient record that would allow an appellate court to review the trial court's decision. Ultimately, and perhaps unfortunately, I do think that there has to be math involved. But I don't think that there's a specific formula that a trial court has to evaluate. In this case, we have a total restitution amount that's due, and then we have Mr. Cavin's monthly income and monthly expenses. But there's no indication that the trial court brought any parity to those two figures. And I think that ultimately that would be the gold star standard on how a trial court could best lay a record for purposes of appeal, or to make sure that there's enough information. And it's just to bring parity to those two figures, and then to determine whether or not it's something that can reasonably be paid by a defendant.
Mr. Raines, do you agree that we're under the Bice-Caudle standard here, abuse of discretion with presumption of reasonableness?
Your Honor, because this case calls for a statutory interpretation, I would argue that we're under a de novo review.
Okay, I'm thinking of the second case, maybe. Okay, yeah.
Well,
Say that again. What do you think what is the standard review on the merits of the restitution amount?
Jurisdictional questions.
I would argue that it's a de novo standard of review, because it still requires this court to evaluate the statute at issue. If this court, though, were to even impose a bias-like standard where there's a presumption of reasonableness, so long as there's a sufficient factual basis within the record to make a determination, I would argue under that statute, or under that standard, that the trial court didn't meet its burden here, that there's not enough within the record to evaluate the trial court's ultimate restitution order, because he didn't fundamentally evaluate Mr. Cavin's ability to pay.
Well, don't we have two issues? Well, actually, two, and possibly a third issue. The first issue is the statutory construction to determine what are the necessary minimum elements to satisfy the statute, correct?
Yes, Your Honor.
And I think we can all agree that's de novo, that's statutory interpretation. But then we move into the merits issue, for lack of a better term, and don't we have two issues there? We have the court's determination of the total restitution amount, and then we have the question of whether there was consideration of the financial means of the defendant, correct?
Yes, Your Honor.
Okay. So wouldn't you agree that based upon the findings by the trial judge in this case, that on the issue of the total amount of the restitution, that he exercised his discretion in a manner in which would be appropriate in this case? He weighed the evidence, he determined the credibility of the parties, and he came to a conclusion and ended up being somewhere between the parties. Now, I'm putting aside for a moment the ability to pay,
Right.
the total amount. Wouldn't you agree that that's the proper exercise of discretion?
Your Honor, I believe that the trial court did exercise its discretion and that it's proper to do so as it relates to a restitution order. But fundamentally in this case, you can't excise the determination of a defendant's ability to pay as that relates to the total restitution amount. And because the trial court didn't put sufficient factual findings in the record as it relates to his ability to pay, that the total restitution amount then therefore can't be said to be proper.
Well, we have in the record that he was working and how much he was making at times. I think this is one where it said, when I'm not in jail, I'm working, right?
Yes, Your Honor. He did testify as to his employment, how much he made, and the expenses that he had. But the trial court in the record doesn't evaluate that testimony or that evidence.
Do we have to conclude then that he did not consider it if he doesn't show his math?
Ultimately, Your Honor, I think that would be
Is that the standard
I think
that you
that would be
think we need to say, unless you, trial court, show us your calculations, then it is to be reversed on appeal?
I think that would be the clearest standard, and I recognize that I'm out of time. If you'd like me to finish the question.
Finish your answer.
Thank you, Your Honor. I think that would ultimately be the best standard and practice for trial courts to adhere to. I do recognize that trial courts...
There's best practice, and then there's the minimum standard. So we can agree that would be best practice.
Yes, Your Honor.
But what I'm asking you about is the minimum to avoid being reversed on appeal.
I think that at a minimum, as long as the trial court shows how it considered a defendant's ability to pay, more so than just saying, I have considered a defendant's ability to pay, that would be a minimum threshold. And that the gold standard would be to do math and literally show how exactly they came to that conclusion.
All right. Thank you.
Thank you, Your Honor.
Your Honors, and may it please the Court, Cody Brandon for the State of Tennessee. The State respectfully requests that this Court reverse the judgment of the Court of Criminal Appeals and affirm the judgments of the trial court because the trial court entered a final order that set a reasonable amount of restitution. First, Your Honors, the parties agree that the trial court's judgments were final and that the Court of Criminal Appeals should have addressed this case on the merits.
Mr. Brendan, I've got one quick question. So when the defendant filed its Rule 11 application, essentially saying that Court of Criminal Appeals should be reversed because it had subject matter jurisdiction, Attorney General's office filed a response saying basically we rely on our briefs and the CCA opinion. There wasn't anything in the briefs, and the CCA opinion you now say was wrong. So what was the basis for the state's response to the Rule 11 application?
Your Honor, I believe the state's response was just based that our position would be the same as it was in the briefs below, which it is here.
So, I mean, it was sort of a meaningless response. I mean, it reads as a meaningless response, but not particularly helpful. I mean,
I'm sorry,
I guess
Your
I'm
Honor.
asking is, did these letters in response to Rule 11 applications just get generated as just routinely without reference to what the actual issue is?
Speaking for myself, Your Honor, every case that I file a letter in response, I've reviewed the record, the briefs, and the Court of Criminal Appeals opinion and make a decision based on that as whether to file a letter in response.
All right, thank you.
Your Honor, the parties agree that this statute, the text of the statute is clear and unambiguous that a trial court has discretion to set payments and installments. I won't spend a lot of time articulating. Mr. Raines has done a good job of setting out the clear text of the statute, that the Court of Criminal Appeals is wrong there. Your Honor's asked about any daylight between the state's position and Mr. Cavin's, and I think the only daylight, as Mr. Raines noted, is that the state doesn't believe we need to get to any sort of default position, that the trial court's order was clear that the restitution was due by the end of the defendant's supervised probation. And
Mr. Brandon, I'm going to ask you the same question I asked Mr. Raines, and that's, is there an amended judgment as to count 2?
not in the appellate record, Your Honor. I don't know if there's an amended judgment that's still sitting with the trial court clerk that didn't make it in the appellate record, but in the record before this court, there's not an amended judgment as to count 2.
I mean, isn't that a problem for purposes? I mean, if there's nothing in the record actually showing that there was an amended judgment entered as to count 2, you know, with restitution, I mean, is that a problem for our determining whether there is in fact appellate jurisdiction?
No, Your Honor. The restitution order, the court entered a separate order on restitution after entering the first 2 judgments that made reference to restitution being set based on the defendant's ability to pay. And the trial court made clear in its restitution order that the restitution order itself, that separate order in conjunction with the judgments, was intended as the court's final order. So
the restitution order combined with the original judgment as to count 2 is sufficient to show that there's a final judgment?
That's correct, Your Honor.
Okay.
Mr. Brandon, tell us why we shouldn't remand this case as far as the restitution amount. That's what I'm asking.
Yeah, because the record is sufficient for this court to review that issue.
That's the easy answer, but tell me why.
That's correct, Your Honor.
But I mean, we generally review Court of Criminal Appeals decisions. We're not usually the first court to make the first review, so why shouldn't we send it back to the Court of Criminal Appeals to do their job?
All right, and Your Honors, that's perfectly within your discretion. You can do that. The state thinks that the case on restitution is clear here, that the trial court set a reasonable amount of restitution, considered a considerable amount of evidence in the record, and based its decision in relation to the 2 factors it was required to consider, and so that this court can go ahead and answer that question and not prolong these proceedings any further, say in the interest of judicial economy, to go ahead and affirm the judgments of the trial court and have the appellate process for this case done with.
What is our standard of review for, or what should our standard review be for reviewing the amount of the restitution?
For that second issue, Your Honor, it should be the Bies-Cottle abuse of discretion with a presumption of reasonableness. The Court of Criminal Appeals has consistently applied that standard, and it's appropriate because it's a sentencing decision by the trial court, where the trial court is weighing a couple of factors, the loss to the victim and the defendant's ability to pay, and coming to a conclusion based on its discretionary weight of those 2 considerations. And here, applying that by a standard of review, the trial court made a reasonable judgment in setting an amount of restitution at $5,500. First, Your Honors, the argument that was presented both to the trial court and at this court that defendant only stole $900 worth of hardwood from Miss Rich's barn is contradicted by the defendant's guilty plea to theft between $2,500 and $10,000. The Court of Criminal Appeals in Colbreth has held that a defendant's guilty plea to theft at a certain value will establish sort of a baseline, a minimum restitution amount.
But if the defendant has very little ability to pay, could the trial court not go below that amount?
It certainly could, Your Honor. Just specifically with respect to the pecuniary loss of the victim, that guilty plea establishes that value as at least $2,500 in this
How
case.
do we know here that the trial court did not, that the trial court considered the defendant's ability to pay when the trial court did not put that on the record in terms of doing the math basically on the record? How do we know that?
I think there's a few things, Your Honor. First, there's repeated references to the trial court's consideration of that. So the first judgments that are entered say that restitution will be set based on the defendant's ability to pay, and that contemplates the later restitution hearing. The trial court, of course, heard extensive evidence on the defendant's ability to pay, and then in the transcript of the hearing, when the court reached its conclusion, stated that it was basing its decision after considering the defendant's ability to pay and his financial resources. And I believe the restitution order itself also states that it considered the defendant's ability to pay. So given those repeated statements, along with the biased presumption of reasonableness, that's the state believes more than sufficient to establish that the trial court considered the defendant's ability to pay, especially when that's judged in relation to the amount that the trial court set.
On the valuation issue, does the trial court's insertion of his personal experience, does that figure into this at all?
No, Your Honor. It was an interesting case.
It was unclear exactly what happened, and the recusal issue, all of them. If you would speak to that and clarify it.
But my read of the transcript, Your Honor, was that the trial court disclosed to the state and the defendant
I'm
that
a woodworker, so
that he was familiar with values of
things.
wood, and offered the defendant an opportunity to seek hearing before another judge. After some time off the record, the defendant announced to the trial court that he was comfortable proceeding without a recusal, without another judge.
Right, so there was no objection to those comments or anything?
That's correct, Your Honor.
Gotcha.
To the extent that that was an issue now, it would be waived, but of course it's not an issue on appeal.
I mean, the trial court essentially became an expert witness at that restitution hearing, though, didn't he?
Well, Your Honor,
Sort of.
the amount of restitution was supported by significant other evidence. The trial court, again, when it announced its conclusion on the record, it didn't incorporate his experience with woodworking, a value of wood. It stated specifically that he was relying on the victim's valuation of the wood, the pictures of the barns, and the previous items crafted with that quality wood, and consideration of the defendant's ability to pay, and his testimony and his plea to an amount of $2,500.
How do we assess whether the trial court actually considered financial ability to pay if the trial judge just says, I've considered it, and the defendant says, there's no way I could afford it? How do we assess that on appeal? Do we simply accept that statement and that's sufficient, or how are we supposed to? I mean, do we do our own math? How are we supposed to do this?
Well, Your Honor, I think it's very similar to most other sentencing decisions that this court reviews, in applying the abuse of discretion standard with a presumption of reasonableness. I don't think this court necessarily has to take the trial court at its word, no matter what, whenever it says that it's considered the defendant's ability to pay, but that statement should be entitled to the presumption of reasonableness, and it's a high bar for a defendant to overcome the trial court statement that it's considered a defendant's ability to pay. But by no means that there may be cases in which the record demonstrates that despite a trial court statement that the ultimate decision was unreasonable, even under the favorable bias abuse of discretion standard.
But I guess in that situation it would be, well, I understand Justice Kirby's question, and maybe I'm misunderstanding to be, does the trial court need to make does it need to utter any magic words? Do there need to be any specific findings? I mean, I take your answer to be that, the appellate court certainly has authority to determine under the abuse of discretion standard that the ultimate amount of restitution ordered was unreasonable. But I guess there could be a preliminary conclusion too that, well, the trial court just didn't consider ability to pay, so we're going to send it back and let the trial court sort of redo that. As to that kind of preliminary conclusion, I mean, what is required? Is it enough that the trial court just says, I've considered ability to pay, so that checks the box of having considered ability to pay, and then the appellate court gets to whether under the abuse of discretion standard of review that amount was nevertheless unreasonable? Or does there need to be more? Does the trial court actually need to show its work to check that box of having considered ability to pay?
It doesn't need to show anything more to satisfy that, but I don't know that this court needs to separate out the consideration of the defendant's ability to pay from setting a reasonable amount of restitution. The statute directs the trial court to set a reasonable amount of restitution in relation to consideration of the victim's loss and consideration of defendant's ability to pay. And of course, that consideration is mandatory, but the court can review the total amount of restitution set under
But from
Uh,
a practical standpoint, they're two separate calculations, right? I mean,
Yes, Your Honor.
on one hand, you look at the evidence on what the value of the property that was stolen, and at some point, there has to be a second step where you compare that to the defendant's available income.
That's certainly one way to do it, Your Honor.
Is there another way? Maybe I'm not understanding the calculation that's involved.
Just to say, Your Honor, that the trial court, so long as it considers both factors, as is required by statute, that it could set a reasonable amount of restitution. I guess to just clarify, it's not necessary for the trial court to make two independent findings, to find an exact value of the victim's loss, enter that number, find an exact value of the defendant's ability to pay, enter that number, and then compare them to arrive at its final number. I think that might be the standard that Mr. Raines is suggesting, that we'd maybe have a worksheet or something where those numbers are entered. So certainly, Your Honor, the trial court has to consider both of those factors, but it can do so in just arriving at its final number of the total amount of restitution, which is what the trial court did here, so long as that number is reasonable in relation to both of those considerations.
Is the only evidence of ability to pay in this record the defendant's own testimony?
Yes, Your Honor. As far as I'm aware, the defendant testified about his income when he's able to work and expected that he'd be able to return to work, and then his expenses.
He said he was a construction worker and made, what, $9.50 to $10 an hour when he was working and not incarcerated, pretty much, right?
I think that's about right.
Said he didn't pay child support, set out what his rent was and how much he paid for electricity and water, and that's basically all that's in the record, right?
That's correct, Your Honor.
Okay.
And from that testimony, the defendant had about $18,000 to $33,000 in available discretionary income over that 2.5-year probationary period. That
Well, if he was working, but we don't know that, do we? We don't actually know in the record the periods he was working and the periods he was not working.
That's correct, Your Honor. The defendant testified that he would be working if he was on probation and that he expected to have his job back. And if circumstances changed and he was not working over that period, that 4035-304, I believe, does allow the defendant to come back to court and ask for a modification of that order. So if there was some problem in the future, it could be addressed in that light. But for those reasons, Your Honor, again, the trial court's decision was supported by ample evidence in the record, including the defendant's plea of guilty to theft of at least $2,500 and testimony from the victim and photographs of the wood that was stolen, the barn that it was stolen from, and the quality of the wood, in addition to defendant's previous sale of a beam of similar quality for $80, one single beam, and the victim testified that about 700 to 800 pieces of wood were stolen. So for that reason, would ask that this court affirm the judgments of the trial court and, again, reverse the judgment of the Court of Criminal Appeals, finding that it lacked jurisdiction.
I have one practical question. So he was sentenced, I think around September 2020. We're looking at about 2 years ago. And he had 2.5-year sentence, right?
That's correct, Your Honor.
So how does whatever, say we reverse or remand, what happens when that he ends his period of probation and this issue of restitution is still up in the air? How's that going to work?
It would certainly cause some difficulties, Your Honor. If this court's opinion reversing came down after his after the period.
Or say we remand for a new hearing, or remand back to the CCA so that the issue of his amount of restitution is still unresolved by the end of his 2.5-year sentence.
Yes, Your Honor. If it, I guess take a couple of scenarios. If it went back to the trial court at a point after his probationary sentence, the the trial court is only authorized to impose a time of payment no later than the end of the maximum term of supervised probation for the offense. I don't remember exactly the term, but it would probably be close to the 2.5 years here, if not a little bit closer. So if there's time remaining in the maximum term of supervised probation, the trial court still could order restitution before the statutory maximum, even if he's completed his supervised probation. Wouldn't necessarily be a condition of probation, but it could just be ordered as an alternative sentence. If that time has passed, the restitution issue would be passed at that point.
I mean, I was wondering, at what point does it become moot? And
I think after the statutory maximum term of probation passed, then the trial court would lose the ability to set restitution after that point and would moot the issue, Your Honor.
And what would be that statutory maximum in this case?
I'd have to check back the statute, Your Honor. I'd be happy to
Me too,
provide
I'd
that.
have to check it. That's why I asked you.
I
Thank you.
apologize, Your Honor.
That was an unanticipated question. You've done a good job. Thank you.
But unless Your Honors have any further questions, we respectfully ask that the judgment of the Court of Criminal Appeals be reversed and the judgments of the trial court be affirmed.
Thank you, Mr. Brandon. Mr. Raines?
Mr. Raines, can you answer my last question? What's the practical effect of either a decision by this court or a remand of the CCA given the 2.5-year sentence?
Yes, Your Honor. I do think that the state is correct when it says that the trial court could look at the statutory maximum term, that is the ultimate cutoff under the statute. I believe because it's a D felony, that would be 10 years, but I would definitely also have to check to make sure that that's correct.
It doesn't matter what range he is? Are you saying he's a range 3 or career or what?
He was range 1, so
Okay.
it would be 2 to 4 years under a D, and I think that the maximum for that is a 10-year probationary term. I would also say that the trial court, if it were remanded back, could also, under statute, extend his probationary term just because the restitution was still outstanding for up to a year. That's allowed by statute. And also there's a mechanism, it's 304H, 4035 304H, that allows for that amount to be converted into a civil judgment as well. So I think that would also be probably the ultimate remedy. If all the other timelines had run, then at a minimum it could still be converted into a civil judgment. There was also, just a couple things briefly, there was also a discussion, I believe Justice Lee, you asked if the $2,500 amount was a floor because that's what Mr. Cavin pled to. And the state said that would essentially equate to the minimum that the trial court would impose based on the plea agreement. And I would just caution this court from setting that as the standard because I think that removes too much discretion from the courts. They are in the best position to evaluate not only the evaluation put on by the state as far as the restitution amount, but also a defendant's ability to pay. In this case, it was required that a defendant be, that Mr. Cavin's ability to pay be determined, but since January, it's permissive. So if a court chooses to do so, I don't think that they should be essentially hemmed in on a mandatory minimum based on the plea amount. I think that they should consider the facts and circumstances, and if it needs to deviate below that, that they be allowed to do that.
So what amount do you say is reasonable here?
I think that the best proof as far as the valuation of the stolen property actually comes from Mr. Cavin. He testified and submitted also into the record a receipt from the load of wood that he admitted to taking. There's a photograph that shows the truck and the load of wood that he took, and there's also a receipt from a lumber company where he sold that wood for I believe it was $230, and then Mr. Cavin testified that generally they resell that for about a 3 times markup.
But to do that, we would be totally ignoring the trial court's credibility determination.
I think that that there's a receipt that lists specific items.
Is that a yes or no?
No, Your Honor, I don't think so. I think it's just weighting the receipt, which isn't as susceptible to credibility issues, more than Mr. Cavin's testimony. And Justice Campbell, you asked if there were any specific magic words that a trial court needs to put down, and I believe the state responded that they don't need to show any more than they just considered an ability to pay. And I would say, even applying the BIS standard here, the trial court still has to do more than just say that it considered Mr. Cavin's ability to pay in this case. It needs to show how it considered his ability to pay in order to receive that deferential treatment.
I mean, wasn't it pretty obvious here that the defendant's anticipated income would exceed by quite a bit? Even taking out rent and utility bills, the amount ordered in restitution?
I don't believe so, Your Honor. We have, because there's not a clear consideration by the trial court as to Mr. Cavin's ability to pay, there are still gaps in his financial resources that are ultimately unanswered. Mr. Cavin testified that when he's not in custody, he also has 3 children that reside with him. One is an adult, but I believe the other 2 were still minors at the time.
But he didn't, he was asked how much he spends in childcare expenses, and didn't have an answer for that. He couldn't estimate, I guess. He said it varies. But, whose burden is it to put that sort of evidence in the record? He was given an opportunity to do that, and other expenses as well, like clothing and food and those sorts of expenses, and that's just, we don't have numbers for those.
Yes,
so
Your
whose
Honor.
burden is that to put that in the record?
I think ultimately it would be Mr. Cavin's responsibility to show his financial resources and his ability to pay. And if there is sufficient, but those are also necessary considerations to truly and adequately consider Mr. Cavin's ability to pay. So if this court finds lacking from the record, then I would request a remand for a renewed sentencing hearing, and to include instructions that make that clear, that the state has to establish an evaluation. They can use a victim's testimony, but it has to be supported, and that it's ultimately a responsibility of a defendant to show their ability to pay. And then also that the trial court has to do more than just say, I have considered their ability to pay, that they have to show how that actually factored into their evaluation.
I want to understand the point that you made when you first stood up on rebuttal on use of the $2,500 valuation for this offense. How is, essentially the argument is that because the defendant pled at that amount, it's an admission that the value of the goods that were taken was at least that much. How is that hemming the trial court in? Because a reasonable amount also has to take into account his ability to pay, and his ability to pay may be less than the value of what he took. So I want to understand what you were trying to caution us about.
Yes, Your Honor. Ultimately, it would be that there shouldn't be a rule or a recommendation to trial courts that, let's take this case for example, Mr. Cavin pled guilty to theft of property over $2,500, that because he pled guilty to theft of property over $2,500, that is an automatic floor as far as restitution goes. And there's 2 reasons why I would caution.
Why is that not an automatic floor as to the value? There's a separate issue on his ability to pay.
Yes, Your Honor.
But why is that not an automatic floor on the value of it?
As it relates to value, the statute directs that the restitution amount is tied to a pecuniary loss, and it defines that as special damages, but not general damages, and reasonable out-of-pocket expenses. So to remove that burden from the state to show a pecuniary loss, I think would be in contradiction to the statute. I also think that it would unnecessarily hinder a trial court's discretion to weigh all of the facts and circumstances as it's setting a restitution amount, including if a criminal defendant has pled out of range. So the actual theft itself could have been less than $2,500, but a defendant can still admit guilt to theft over $25,000 as part of the plea bargaining process, to be exposed to a longer probationary sentence or harsher terms, those kind of things, whatever the deal may shake out to be. And so I think for those reasons, there just shouldn't be a bright line drawn connecting valuation to the plea amount.
Thank you.
Thank you. If there are no further questions, I would ask that this court find that the amended judgment, including the restitution order issued by the trial court, was sufficient to create a final judgment that was ripe for appeal, and would also ask that this court, should you choose to address the issue of the total restitution amount, find that that was an error because the trial court didn't adequately consider, with sufficient factual findings in the record, Mr. Cavin's ability to pay. Thank you.
Thank you, Mr. Raines.